bienvenido a mi canal. Yo me llamo Siri. Soy una abogada afro-latina licenciada practicando la ley criminal, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a continuar hablando de Alex Murdaugh. Si quieren más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latino criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. Listen. Okay, you guys, in some of my other previous Alex Murdaugh videos, we discussed some of the documents as it relates to his motion for a new trial, the appeal, and the like. Okay. I figured in this video we would take things back, kind of way back to the beginning, and just discuss the initial appellate brief that he filed before filing the motion for a new trial and asking the Court of Appeals to put this motion on hold. Does that make sense? So anyways, as we continue our coverage into Alex Murdaugh, I just want to make sure we're all on the same page. So let's go ahead and get started in discussing the appellant's initial brief. As you guys can see here, it says the state of South Carolina respondent and Richard Alexander Murdaugh is the appellant. Initial brief of the appellant. Before we get into anything further, I will just tell you this. In this brief, the first thing I noticed is that it was separated by two distinct different arguments, right? But that should not be confused by the fact that each argument has its own subsection and supporting sub-arguments that Richard and his attorneys want the appeals court to know. Does that make sense? Let's go ahead and get into it. I'll just read the two separate arguments and then I'll just go into the further sub-arguments that I think are important because they articulated it to the court. Argument number 1, Murdaugh was denied his constitutional right to a fair trial by an impartial jury free from outside influences. Let me stop right here before I get into the sub-arguments, right? So basically their first argument is the overarching claim. Underneath that, they're explaining how they feel like he was denied his right to an impartial jury free from outside influences, okay? So let's go ahead and get into that, but keep that in mind as we go forward. There is an irrebuttable presumption of prejudice when a state official secretly advocates a guilty verdict in the jury room during a criminal case. The U.S. Supreme Court holds that in a criminal case, jury tampering is presumptively prejudicial. The presumption of prejudice is irrebuttable when a state official tampers with the jury during a criminal trial about the merits of the case. The state cannot rebut the presumption of prejudice by arguing Ms. Hill's jury tampering was harmless, because secret advocacy for a guilty verdict in the jury room during a criminal trial by a state official is a structural error in the trial that cannot be harmless. The trial court's finding that Ms. Hill's comments to the juror were not overt as to opinion is unsupported by and contrary to the evidence in the record. Even if the presumption of prejudice was rebuttable, the state did not rebut or even attempt to rebut any presumption of prejudice in this case. Prejudice was proven at the evidentiary hearing. Okay, before we get into the second argument, do you see what I'm saying there about how this argument is laid out or how it's framed? The first part is, okay, here's the argument. He was denied his right to a fair and impartial jury free from outside influences. Sub-arguments. Because of that, and because of Ms. Hill's witness tampering, why do I keep hitting myself on his microphone? You know what? I keep it so close to myself, like when I'm talking to you guys now, because at the beginning I had really bad audio issues, but now it's like I'm kissing the microphone and every 2 seconds my chin hits it and it becomes frustrating for me. But anyways, let's continue. Okay, now it's articulating more that this is jury tampering, and it's also stating that the prosecution or the state cannot rebut the presumption. Remember how we talked about rebuttable presumptions, specifically as to the prejudicial effect that Ms. Hill's comments had on the jury? One of my last videos, I don't remember which one it was, but we talked about it. So that's just what they're articulating here. And remember, we're going way back. So this is the initial appellant brief in this case, but let's go ahead and carry on. 2, the court allowed the state to introduce improper character evidence and other irrelevant and unfairly prejudicial evidence that so infected the trial with unfairness as to make the resulting conviction a denial of due process. Evidence of financial crime should have been excluded under Rules 404B and 403 of the South Carolina Rules of Evidence. I'm going to stop right here and I'm going to just tell you something really quick, okay? I'm not licensed in South Carolina, but 403, where I'm licensed to practice, essentially is that the evidence is more prejudicial than it is probative, right? So sometimes the court will not let in certain evidence when it's more prejudicial than it is probative. I'm willing to bet my bottom dollar that that's what they're talking about here. Okay. And 404B is just prior character evidence. So, in order for a character evidence of a specific person to be admitted into a trial, there needs to be a prior and a separate hearing in order for that to be admitted. So, that's what I believe that they're saying here. And again, I'm not licensed in South Carolina, but I'm just telling you based on the rules of evidence as I know them, I'm pretty sure that's what they're saying. The state's theory that Murdaugh murdered his wife and son in cold blood to distract his law firm from investigating alleged financial improprieties is illogical, implausible, and unsupported by the evidence. Any probative value of the evidence concerning the alleged prior bad acts was substantially outweighed by the unfair prejudice that resulted to the defendant, therefore, it should have been precluded. I'm going to stop right there just to gloat just a little bit because I'm telling you based on experience, right? So, what they're saying in this section here is that the prior bad acts, as I told you, 404B, right, should have been excluded because they were unfairly prejudicial and more so unfairly prejudicial than probative. That's 403. Does that make sense? So, basically, what they're arguing is because evidence of his financial transactions, what have you, are prior evidence of bad acts. There should have been a hearing prior to introducing them into the trial for the court to have made an independent determination before the introduction of it, and the introduction of it subsequently was more unfairly prejudicial than it was probative. I'm laughing to myself because this, right? Even though I'm reading you these documents or what have you, a lot of times when I'm interpreting them for you, I'm just thinking as I'm telling you this. So you'll see me looking to the left or looking to the right or up and down to the sky, to the, all of this stuff. It's because I'm trying to explain it to you based on my memory of it and what I know it to be. Does that make sense? Anyways, let's go ahead and carry on. Murdaugh did not waive his objections to the financial crime evidence by testifying, and the trial court erred by concluding Murdaugh opened the door to the financial crime evidence by questioning a witness about Murdaugh's relationship with Maggie and Paul. Okay, let's just stop right here and I'll explain to you guys a little bit what opening the door means, okay? So typically when you're in your trial, and let's assume that you don't have a prior ruling on 404B and you don't get to talk about the defendant's prior bad acts, right? So let's assume that all of that is the case. There are certain limited circumstances by which one of the parties in the case can open the door to introduce said evidence. Does that make sense? Does that make sense? Does that make sense? I didn't watch this trial. I told you guys previously I didn't follow it. What I'm surmising is that one of the witnesses testified about something that opened the door for the prosecution to then inquire about it. I think what I read, you guys do not quote me. I did not watch this trial. But if it was televised, I don't even know. Anyways, I didn't watch it. What I read was that one of the witnesses was asked by defense if they could think of any reason by which Murdaugh would do any of this. And I don't know what the response was, but the prosecution took that as opening the door. They allowed introduction. The prosecution took that as opening the door, which then allowed the court to allow them, the prosecution, to introduce evidence of the financial crimes. So anyways, that's where we're at. Let's carry on. Subsection B. The state violated Murdaugh's due process rights by using his post-Miranda silence to impeach him. C. The trial court committed reversible error by allowing the state to introduce evidence of an unscientific expert performed by an unqualified Charleston County deputy in a rebuttal case. D. The trial court erred by admitting irrelevant and unreliable firearms evidence. 1. The trial court erred by allowing SLED's firearms examiner to provide irrelevant, unreliable, and confusing opinion testimony. 2. The trial court erred by allowing the state to introduce multiple guns seized from Murdaugh's residence when no evidence linked the guns to the murders. 3. The trial court erred by allowing the state to introduce gunshot residue results of a raincoat into evidence when no evidence linked the raincoat to Murdaugh. Okay, let's stop right there so I can give you guys my opinions just on these subsections. Yeah, let's just stop right there. So again, I don't know what post-Miranda silence they're referencing. And a lot of times when you're doing a criminal case and a criminal defendant is, they have the right to remain silent. So if the criminal defendant exercises the right to remain silent, the prosecution has a duty to not use that silence against him or her, right? So I don't know what post Miranda silence they're talking about, but maybe we'll get into it. But I don't know if we'll get into it because this whole brief is 132 pages. I don't know if I'm gonna read it all to you. But as far as we get into it, I will let you know. Okay. Now let's continue. I think I've talked to you guys before. I honestly don't remember what case it was, but I'm pretty sure we talked about Shreck hearings and firearms experts and tool mark analysis and such, right? But basically, a Shreck hearing is a hearing by which someone challenges the expertise of said individual expert, right? So if they're challenging whether a firearms expert can testify credibly as to tool mark and firearm analysis, what they'll do is they'll have a Shreck hearing on the issue if the court so allows, and then they'll question the expert, blah, 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 and the court issues an order as to whether or not this expert is allowed to testify to his or her expertise, right? Again, I don't know what expert they're talking about here, but it seems like defense doesn't like the fact that the court allowed this person to testify. And so now they're trying to challenge their credentials. I don't know how far that's going to get them. And we don't even have to worry about it because he was already granted a new trial. But that was an argument that they were making initially. Let's carry on. Argument 1. Murdaugh was denied his constitutional right to a fair trial by an impartial jury free from outside influences. The trial court found Ms. Hill tampered with the jury during Murdaugh's murder trial. The only evidence the state presented contradicting sworn testimony describing the tampering was Ms. Hill's own denial, which the trial court found not credible. The trial court found she was motivated by a desire to sell books. The trial court found she was attracted by the siren call of celebrity, and she allowed public attention of the moment to overcome her duty. And one juror testified that Ms. Hill's tampering did influence her verdict. But the trial court nonetheless denied the motion for a new trial by committing legal error and by abusing its discretion. The trial court erred when it refused to presume that jury tampering during trial by a state official advocating a guilty verdict is prejudicial to the right of the accused to a fair trial, and when it held that deliberate jury tampering by a state official seeking a guilty verdict was harmless, because in its opinion, the correct verdict was rendered nonetheless. The trial court abused its discretion when finding Ms. Hill's tampering did not affect the jury's verdict despite a juror's uncontradicted testimony that her verdict was affected. The court, therefore, should reverse the trial court's order denying Murdaugh's motion for a new trial, vacate Murdaugh's murder and firearms convictions, and remand for a new trial. Okay, we're not going to get into all of that because we discussed it in some of the past videos, but basically what they're saying here is, as they've said previously and as they've continued to hold or continue to say, because they're not a court, continue to say, they're saying that Ms. Hill is such a vile creature, that her actions and her words and her tampering with the jury made it so that Alex Murdaugh's trial was not done by fair and impartial jury. Does that make sense? Let's carry on into the next segment. The trial court allowed the state to introduce improper character evidence and other irrelevant and unfairly prejudicial evidence that so infected the trial with unfairness as to make the resulting conviction a denial of due process. The trial court committed numerous evidentiary errors, repeatedly admitting over objection evidence that was irrelevant, unfairly prejudicial, or otherwise prohibited by South Carolina rules of evidence. Those errors were standing alone reversible errors. Additionally, they combined to create a due process violation because they rendered Murdaugh's criminal trial fundamentally unfair. The inquiry to determine whether the combined effect of trial errors violated a defendant's due process rights is whether the errors rendered his defense, quote, far less persuasive than it might otherwise have been. As explained below, the evidence that the trial court erroneously admitted without exception served to materially undermine Murdaugh's defense and to bolster and to plaster over holes in the state's case. The state was allowed to present day after day of character evidence against Murdaugh under the thin guise that his thereby demonstrated bad character provided a motive for the murders. The state was allowed to impeach Murdaugh's exculpatory testimony with his exercise of his post-Miranda right to remain silent. Improper scientific testimony was admitted in the state's rebuttal case to plaster over the fact that only someone other than Alex could have thrown Maggie's phone into the roadside brush from where it was recovered by law enforcement. Improper expert testimony about firearms was allowed. Firearms unconnected the murders were sent into the jury room during deliberations, and gunshot residue on a raincoat unconnected to Murdaugh was admitted into evidence to plaster over the state's failure to recover any murder weapons. These evidentiary errors were, standing alone, reversible errors because there were substantial errors affecting the result of the trial. Collectively, they violated Murdaugh's right to due process of law because they rendered his defense far less persuasive than it might otherwise have been had the trial court consistently enforced the South Carolinian rules of evidence. Okay, I'm going to stop right there and just explain something a little bit more to you. So I think this section, to me, just reads far less credible. I just think it reads far less credible, and I'll explain. Understanding, I did not closely follow this trial. This is just a first impression opinion based on what I'm reading right here, okay? Basically, what I think is this. I think in every single trial, one side or the other, at numerous different points throughout the trial, will feel aggrieved by the trial court. And I felt that way. Right? But I don't think that always, just because you feel aggrieved, means it's an actionable error on behalf of the trial court. So reading this is more like, okay, well, there were errors because they admitted evidence. Okay, well, the trial court said that the evidence comes in, gave you its basis for it, and that was that, right? Or, the trial court allowed the firearm expert to testify. Okay, well, he was established as an expert, and the court allowed his expertise or her expertise. Like, I don't know, this just seems like a lot more watered down and weaker than the previous argument to me. And you don't really have to take my word on that because we're kind of working backwards and I already know the outcome of this. But basically, just on first impression, that's how I feel. Let's carry on. Evidence of financial crime should have been excluded under Rules 404B and 403 of the South Carolina Rules of Evidence. In order to admit evidence of bad acts not resulting in conviction, the trial court must, as a threshold matter, determine whether the proffered evidence is relevant. If the trial court finds the evidence to be relevant, the judge must then determine whether the bad act evidence is admissible under the terms of Rule 404B. While evidence of prior bad acts generally is not admissible to prove the character of a person in order to show action in conformity therewith, a court may admit such evidence to show motive, identity, the existence of a common scheme or plan, the absence of mistake or accident, or intent. Rule 404B. Importantly, admissibility of such evidence requires it logically relate to the crime with which the defendant has been charged, and that it be clear and convincing. Okay, I'm going to stop right there just to gloat a little bit. The only reason I kind of knew that already, despite not being licensed in South Carolina, is because every state has their own specified versions of the same rule. Okay, really, that's what it is. Okay, and so when they're mentioning 404B, I'm like, oh, great, prior bad acts. You know what I'm saying? So anyways, that's what they're arguing here. But let's go ahead and carry on. The state's theory that Murdaugh murdered his wife and son in cold blood to distract his law firm from investigating alleged financial improprieties is illogical, implausible, and unsupported by the evidence. Okay, so I'm going to stop right here and explain it to you. So the financial crimes or evidence of prior financial crimes are the 404B evidence, or is the 404B evidence that the attorneys for Murdaugh are talking about, right? So they're saying that the court improperly allowed such evidence to come in. And because of that, it was reversible error. The state argued that on the day of the murders, June 7, 2021, Murdaugh's financial schemes were about to come to light because of two reasons. First, Jeannie Seckinger was questioning Murdaugh about the whereabouts of the attorney's fees from the Ferris traffic accident he worked on with co-counsel Wilson. Second, the state asserted that the hearing on the motion to compel financial information from Murdaugh in the Beach case would have exposed Murdaugh's financial schemes. Therefore, Murdaugh murdered his wife and son to distract from these two matters and garner sympathy from the community. There was no evidence introduced to support the state's motive theory. Without any evidentiary support, this theory is pure illogical speculation. Furthermore, the state's evidence contradicted its theory that June 7th was a tipping point. Seckinger testified that she stopped questioning Murdaugh once she learned his father was being admitted to the hospital again, and she offered her support to him as a friend. Murdaugh's father, in fact, died 3 days later. Seckinger also testified that she and the firm did not suspect that Murdaugh was stealing money. Rather, the concern was Murdaugh was concealing money to avoid disclosing it in response to discovery requests in the boating accident lawsuit. In addition, Mark Tinsley, plaintiff's counsel in the boating accident lawsuit, conceded that nothing explosive was expected to occur at the June 10th hearing. Okay, I'm going to stop right there because this section of the brief to me more sounds like just whining and complaining, because the prosecution doesn't have to establish by all reasonable doubt the motive behind it. They don't have to do that. They don't have to do that, okay? All they have to say is, this is why we believe XYZ happened, okay? Because I implore you, if any of you guys ever sit on a jury for a criminal case, just remember I said this to you. When the prosecution at the end of the trial is going through all the elements that they have to prove, I want you to look for the motive. I'll wait. I want you to look for the why. Again, I'll wait. And that's because the prosecution doesn't have to prove it to you. Why is that? Because how are they supposed to know? They put forth a motive that they believe this person committed the crime for, but there's no reason that they would know what's in the mind of someone else. So I think this section sounds like whining and complaining and moaning. I don't know that the court really considered this, because all of the stuff we've talked about so far is about Hill's tampering with the jury. So, I mean, they could have saved themselves some credibility by not including that in their brief. But who am I? Conclusion. Any person accused of a crime, even Alex Murdaugh, has a constitutional right to a fair trial. When a fair trial is denied, he is entitled to a new fair trial. He is not required to earn it by proving he would have been acquitted had he been given a fair trial the first time. Judges' opinions regarding the strength of the state's evidence against the accused are not a substitute for the presentation of that evidence at a fair trial. The court should therefore reverse the trial court's denial of Murdaugh's motion for a new trial and vacate his murder and firearm convictions. Additionally, the court should vacate Murdaugh's convictions because the improperly admitted evidence deprived Murdaugh of a fair trial, and its consideration by the jury was not harmless beyond a reasonable doubt. Okay, so as we know, because we're kind of looking past as we're talking about this brief right here, the Supreme Court of South Carolina did reverse the trial court's decision and did grant Alex Murdaugh a new trial. Those were my opinions on the brief so far, or the brief as a whole. And I'm telling you, because I'm being honest with you, I didn't read all of it because my throat and lungs and voice are tired, okay? And it was 132 pages, but I will link it down below if you guys want to read it. If you want my opinions on any specific sections, you go ahead and let me know and I'll make sure to do it for you, because I told y'all I was going to do this in every video moving forward. I would love if you guys please did me the favor of commenting on this video. If you liked it, can you tell me why you liked it? If you want more opinions on something, can you tell me that you want more opinions? Can you please subscribe? Can you like it? If I didn't say that already, did I say that already? But can you do these favors for me, please? It really helps me out. As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.